right, so we're just past 1 o'clock. So we have a lot of content to cover. So we'll get started. Hello, everyone. Welcome to the first webinar in the ABA Forum on Construction Law's three-part series, Navigating Uncertain Times and Unprecedented Challenges in U.S. Construction. My name is Erin Fallon, and I'm a managing director in JSL's construction advisory practice, and I couldn't be more pleased to lead today's discussion focused on strategies for navigating tariffs and cost escalation. Before getting into the webinar content, however, I would like to briefly introduce our three amazing and extremely knowledgeable panelists. So I'm going to start off with Joe Darr, who is Associate General Counsel with Brasfield and Gorrie, and he's going to be providing our contractor perspective today. Next up is Claire Groover, who is up counsel with Becker, and she's going to be providing our owner's perspective during the discussion. And last but certainly not least is Chris Ng with Gibbs Giddon. And he's the managing partner of Gibbs Giddon, and he's going to be providing the supplier perspective today. So before discussing some of the strategies for mitigating tariff risk, we would like to take a few minutes to provide an overview of the history of tariffs and the tariff situation today. So Chris, can I ask you to lead us through that discussion?
Yeah, thanks, Erin. Obviously, our focus today is to show how owners, contractors, and suppliers can contract and otherwise navigate our way around the tariff chaos with some practical contract clauses that you can take back to the office. But if you'll indulge me for just a few moments, let me set the table with a little bit of background that I think is helpful to what we hope to accomplish today. As most of you know, tariffs have been around for a long time. Back in the 19th century, it was our primary revenue source for the federal government. And that changed over time, especially past the Smoot-Hawley Tariff Act, if you remember that in your high school history class. And after World War II, tariff rates steadily declined as countries started looking at international trade and economic integration. Of course, we had the free trade agreements earlier this century, the establishment of the World Trade Organization and such. Things changed with the US-China trade war starting in 2018, and it continues to shift under the second Trump administration as it defines its tariff policies. So obviously a lot happening right now, especially 19 minutes ago, I saw on Reuters a escalation here between the U.S. and China, between our two leading officials here, going back and forth. China with the rare earth element export controls, and President Trump threatening a massive tariff increase. So things are changing today, right before our very eyes, which of course is why we're doing a lot of this today. But let me try to articulate the buckets of tariffs that you all hear about in a little bit more detail. Number one is our national security tariffs. We call these Section 232 tariffs. In June 2025, steel, aluminum, copper, most copper products raised from 25 to 50%. We have our special Section 301 tariffs on China, the additional 25% additional duties. Some refer to it as a 30%. It's really 25%, but it gets complicated on your Chinese goods, including many electrical and construction inputs. You have reciprocal tariffs backed by executive order in April 2025. We have a 10% baseline on most imports, with higher rates going from 15 to 40%. On some countries. So in Mexico, 25%, Canada, 35%, unless they happen to fall within an exception. And then we got a brand new one yesterday that went into effect on wood products. So 10% on softwood, lumber, timber, 25% on cabinetry, vanities, and upholstered wooden furniture. So, you've got the stacking issue where a Chinese wood cabinet might be facing a 25% Section 301 tariff, add another 25% under the Wood Products Proclamation, a 10% reciprocal baseline, and maybe you're up to 60%. But no one really knows, except for the really smart people that do this. And that is the brokers that really do 90% of this exercise. The actual duty depends on our harmonized tariff schedule, the HTS. It's put out by the U.S. International Trade Commission. There is a website link, I believe, at the end of our materials for those of you that really feel excited about looking at the HTS and the schedule of tariffs. It provides the current tariff schedule in searchable form, updated regularly as you might imagine, in this day and age. So that's all happening in the background. We all know, of course, there is a legal challenge, not just by the U.S. Court of International Trade and the appeals that followed, but of course, the Supreme Court of the United States is going to hear these cases on November 5th. Oral arguments will be made to see whether the administration has exceeded its statutory powers. What does that mean? I think we'll touch on that in a little bit. In addition, I wanted to just paint a little bit of a picture of the tariff process and how it works when goods actually arrive in the United States. I always thought of the tariff process like a toll booth on a dock, right? In reality, of course, it's not that. It's an electronic trust-based system that runs on bonds, the brokers that I mentioned, and delayed settlements. So first of all, when you think about this process, we think about who are our importers of record. And to be honest, I don't think a lot of us know who are actually legally responsible as the IORs or importers of record for the goods that come into the United States. So a lot of times they're U.S. distributors. Think Klockner Metals, Nucor for steel, Rexel, Graybar for electrical, and so on. The distributor in those cases is the importer. In a lot of cases, you have a foreign manufacturer's U.S. subsidiary that is the actual importer. So you may have Siemens USA, right? That's importing switchgear manufactured by Siemens Germany. So they act as the importer, the USA entity, just like Mitsubishi Electric USA or Schneider Electric USA. But again, at the end of the day, the custom brokers do 90% of the work. They're not the importer of record. They're just the agent filing on behalf of the importer of record. So what actually happens is an electronic, not a physical exchange of cash, right? So tariffs aren't collected at a toll booth. It is all through what we call the automated commercial environment, backed by importer bonds, which allow cargo to be released into the United States before the Customs and Border Protection has money in hand. So what they do is the vessel arrives, the flight arrives, the ship arrives, and they file entry documents within 5 days. Those entry documents are basically saying, hey, Customs, here's what's arrived. Let me take custody and get the goods released into commerce or into bonded storage, as we're going to talk about in a moment. Then you have a 15-day rule or a 10 days after release rule, which gets them liquidated and paid. So again, the CBP, or the Customs and Border Protection, relies on bonds, not cash. Containers move inland while the broker and the importer settles the duties in the background. And that's basically how this all sort of works. And I know there was a question that was provided right before today's presentation about, what happens if the duties are calculated incorrectly. I mean, it's a massive dilemma for our importers of record and the brokers. If you overpay, you can protest within 180 days to correct the entry, hopefully get some money back. But there are significant underpayment penalties, liquidated damages, negligence penalties, etc. So no doubt for high value construction goods like steel beams, switchgear, even small misclassifications can mean six-figure swings. So a lot of companies do hire customs counsel or auditors to help with reviewing the process to make sure it's done correctly. As I mentioned briefly, bonded warehouses, really, I think something that we miss in the construction world about how this all sort of works. The rules that I just mentioned about the timing, about importing, that's typically the standard import consumption entry timeline. But that's not always how goods come into the United States. In fact, there are two devices that importers can use to delay the payment of tariffs. And of course, this is interesting to hopefully those of you upstream, owners, contractors. You should be thinking about this if you're not already. First of all, it's a bonded warehouse. A bonded warehouse is a secured facility under U.S. Customs supervision where imported goods can be stored without paying duties or tariffs for up to 5 years. Think of it as a duty-free storage garage. You can park your goods there for years. You can't touch them and modify them. You can preserve them. There are 1,700 bonded warehouses in the United States. But think about what this does. It allows a tariff timing hedge, right? It allows us to see where tariffs might go if we think they're going to get rolled back. There's a cash flow benefit, no doubt. It could postpone millions of dollars in tariff payments until the goods actually sell or are put back into the stream of commerce. And theoretically, if the goods get re-exported, there is no tariff, there is no payment, there is no duty payment to be made. So bonded warehouses are taking an important part of this whole tariff war and something that we should be thinking about. Now, yes, I know Reuters just reported this. that they are at capacity for the most part. And if they're not at capacity, no doubt there is escalation of 4 times what it used to cost to have your products in bonded warehouses. Now, there's the foreign trade zones, which are a designated area inside the US, but legally treated as if it were outside the US customs territory for tariff purposes, kind of like your embassy, right? Think of it as a duty-free industrial park. Here, you can store, repackage, assemble, or even manufacture inside the FTZ. Pfizer used this during COVID, right? They weren't paying tariffs or duties on drug components. Instead, they put them in an FTZ, they manufactured them and store them until FDA approval. So it really helped Pfizer introduce their product during COVID. And it's the same sort of thing here. There are 2,240 free trade zones or foreign trade zones in the United States, in all 50 states. And we employ 600,000 plus people in these FTZs. And again, as opposed to the bonded warehouse where it's a 5-year limit and you can't touch the goods, with an FTZ, manufacturing and processing is allowed. So if your finished product carries a lower duty rate than its components, you have a lower duty when it enters the U.S. commerce, right? What we call an inverted tariff benefit. So these two timing tools and optimization tools are important. So to summarize, look, tariffs are not a pay-to-pass toll. They're an accounting exercise. It's done with classification, timing, bonded, security, and paperwork. Bonds make the system run. Custom brokers are the gatekeepers. They run this process. Bonded warehouses and FTZs are the true lever for managing tariff timing. Again, back office accounting events with strategic options, and these things matter.
Thanks, Chris. That was thanks for that overview. It's really, really helpful to understand that background. So one thing I wanted to mention that several of you submitted questions during registration, and we're our goal is to answer as many of those as we can throughout the presentation. If you do have additional questions, you can use the chat function, and we'll also try to answer them in live time. So that's also available to you. So now that we know how the sausage is made, let's start to dive into some of the tariff concerns that keep, owners, contractors, and suppliers up at night. So Claire, can you start us off in that discussion with the owner's perspective?
You bet. And Chris, I want to add kudos to your presentation because from the owner standpoint, because the owner standing at the top and kind of the instigator of all of the fun and the duty to pay, the owner's lawyers really still need to know at a granular level how the pricing components along the way will impact its GMP. And I don't know that there are really very many scopes that are being bid as lump sum. All of the contracts that I'm dealing with right now, both in the public sector and the private sector, are typically a GMP in the public sector. And so cost mitigation, the risk of the tariff itself is important no matter whether it's public or private. I've seen some very clever and appropriate efforts on the part of owners and contractors to, of course, work together to make sure that when they're buying out subcontracts under the GMP, that they get certainty as to the tariff. How much is it now? What is the likelihood it'll go up? Who knows? That's the answer to that question. But the question is, what is it now at the time of contracting? And we presume that it'll be in your pricing. But then the other piece that, of course, all parties, supplier, contractor, and owner, or the owner doesn't want to negotiate it because the owner wants to say, okay, now it's all capped. It's the risk that the subcontractor and the contractor take. And of course, the owner needs that for certainty in dealing with its lender, taking those contracts, packaging them, and convincing the lender that it's a good deal to get involved in. And as we all know, lenders only have a certain tolerance for risk, and they want to know for sure that the contract value is not going to go up, and certainly not going to go up in a method that's out of control. So what are there's some mechanisms we're going to talk about in a minute under the contract where we can address those sorts of risks. The other thing that is really important, if you don't have a private lender and you're in a public environment, you obviously have time and the governance policies, the approval policies in getting from the infrastructure team up to board approval, and getting the boards comfortable with the risk environment that we're working in from a cost standpoint. Delays are an important feature of this. How much, is it going to go smoothly? Is it not going to go smoothly? But in the end, we're not used to having taxes, tax rebates, and a tariff under the FAR, Federal Acquisition Regulation, is considered a tax. And so for any tariffs that are imposed after contracting, those are new items that arguably the owner would be responsible for, just like with taxes, after imposed taxes. And so that is another risk that we don't really deal with so much in the private sector, but definitely in the public sector, is the risk during procurement. How many bid protests are we going to have where a bidder has proposed and has failed to include a tariff or the amount of the tariff in the proposal, and the timing of withdrawing a proposal or having a proposal be accepted, and then the contractor's stuck because there's just no wiggle room. And we'll talk in a minute about the contract provisions that I sort of see as, bookended by contractor pays it all, owner pays it all, and then of course there are the intermediate positions that we can take. Joe, tell us a little bit about what you face every day.
Yeah, so from the contractor's perspective, there are obviously going to be a lot of concerns when it comes to these wacky tariff increases we're seeing up and down all the time. But the number one concern for contractors is probably the most obvious, which is unforeseen cost escalation. So, as Claire mentioned, a lot of the contracts that she sees and that I see from us as a contractor are being performed on a cost plus basis with a guaranteed maximum price. And, when we get to our guaranteed maximum price proposal or GMP amendment, that we're giving our owners saying, hey, this is the price that we can build this project for you at, and we're guaranteeing that we won't exceed that price. That pricing is based on the taxes and tariffs that are in place at that time. We can't really figure out and guess at what those tariffs would be in the future, so we don't put it in our pricing. And also our owner clients wouldn't want that, right? They don't want to get a price that's higher based on tariffs that may or may not happen. So again, these tariffs are tremendously impactful from a contractor's perspective, in the sense that if you don't have the right contractual language in your agreement with the owner, it's possible that you might be left out to dry on that and eat it as a cost that won't be reimbursed by the owner. And it wouldn't take too much, given our thin margins, to have a job turn from one that's modestly profitable to a complete loser due to tariffs that we couldn't foresee, nor price into our GMP amendment because the owner didn't want us to have us do that. Which then leads to our second biggest concern from the contractor's perspective, is having the right contract language in place to address what is now a real issue, to the point where we've got an hour webinar on it with the tariffs, right? So under in the world I live, I deal with a lot of AIA contracts, and in particular the A133 for cost plus guaranteed maximum price contracts. There is a provision in there that provides, the default language provides that sales, use, or similar taxes are considered a cost of the work that will be reimbursed by the owner. I know Claire had just mentioned that the Federal Acquisition Regulations provide that tariffs are a tax that would be covered by the owner. Whether or not that's true under the form AIA agreements, I don't know. Is it a sales use or similar tax, a tariff increase? Would that be considered a cost of the work under the default language? I'm not aware of any case law or anything else that's definitively answered that question. And frankly, at this point, it would be silly just to rely on that default language to adequately protect any of the parties that are signing the agreement. With that said, the best practice is going to be to have express language that addresses tariffs and how that risk is being shared or handled between the owner and the contractor. And ultimately, those terms are going to flow down to our trade partners as a contractor. So it's important to have those express terms to make sure everybody's on the same page. And as Claire mentioned, we're going to be getting into some specific examples of potential contract provisions in the next section. But before we move on to that, I'll say that the last concern for contractors regarding tariffs would be the procurement uncertainty that comes with these constantly changing tariffs, and in particular, trying to figure out the timing of buying out your trade partner contracts and making sure that the materials and equipment we need to get the job done are ordered in a fashion that they're going to be showing up to our job site on time so that we can build our projects timely for our owner clients. And tariffs can have a real impact on our ability to stick to timelines and schedules that we have promised our owners that we'll get the project done by. So those are our three main concerns that contractors are having right now with these issues. And I know that Chris is going to have a couple words, I assume, on the supplier's viewpoint on tariffs.
Yeah, Joe, and well said. Did you send me a demand letter on behalf of one of my supplier clients that if we don't supply, we're going to be paying your LDs? Maybe. I think that sounds familiar. We'll talk about that.
Never. We play nice.
We may talk about that in a little bit. I think what's cool about this webinar and this presentation is that I think for all of us, regardless of whether you represent owners, specialty trade contractors, GCs, suppliers, it's a skeleton, right? And really you can see the pressures from one end to the other, and that we're all in the same boat. And the same risks, the same concerns are probably similar for suppliers that it is for GCs and contractors. We're concerned that we're going to be legally obligated to deliver at the old quoted price despite a new tariff. So what do we do? Do we incur the loss and perform, or do we hold our ground and say, wait, no, we're entitled to an adjustment, hopefully because the contract documents or the provisions allow us to, or we're going to make a force majeure argument or a commercial impracticability argument and risk the assessment of LDs through the chain. So that's obviously a big risk, and it's the unpredictability means impossible pricing at this point. It is a daily cash flow exercise and contract risk event in talking to my clients. Every new proclamation that comes out of Washington can turn a profitable quote into a loss tomorrow. So the volatility, liquidity, and uncertainty is problematic, and it's not as easy as like, let's just substitute domestic or friendly origin equivalents. It's difficult to do so because a lot of our domestic mills are running at full capacity, or they raise their prices significantly so that it doesn't really matter. So are we going to stockpile to try to avoid some of this? Well, we're tying up capital, right? We're paying for storage and insurance. So there's a lot of issues here and a lot of strain that I hope everyone understands for the suppliers too. It's stressful. It's a stressful time. And they are obviously the financier sometimes, right? Waiting, they pay some of these duties and then they're waiting 30, 60, 90 days to get paid or longer. And so there's definitely cash flow constraints as well and concerns. So and I'll say this, look, at the end of the day, I've got one right now. My clients are worried about project delays and cancellations. An owner may terminate for convenience. Well, what happens to my goods? My $10.5 million goods that I've got, because I got the dispute right now on my desk. What do I do with that? Who am I going to get my money from? Is the owner responsible? So we're worried about delays, cancellations, and at a macro level, worried about fewer projects, fewer orders, and cancel projects from just an economic level. So lots of things happening on the supplier end.
Yeah, and I want to loop back just a second, Chris, because you had made a point about the documentation for the material purchase, and that sometimes multi-million-dollar deals are done on, you know, an invoice and a purchase order. And I've seen that myself, and it's really interesting, and not and sort of in a Chinese proverb sort of way, you know, may you live in interesting times. But the documentation, you know, while the you know, the owner is trying to drive the project almost sometimes from the back seat, like you're driving as the back seat passenger. And it's for control, people that like to control their destiny. That's a very uncomfortable position. And so the more information that I think owners have about what is really going on down at the second and third level, and what's going on the dock, and how the process happens, the better off owners will be in the negotiation, because you want all parties to be on the same kind of understanding of the process. Well, in the visibility of documentation, Erin, the next slide will show what may not be interesting to many folks, but it's an example of what is going on in the real habitat of this construction project. And the reason that I have been kind of a pest, particularly with my public owner client, is regarding the documentation. This, because the Court of International Trade has already imposed, they ordered a permanent injunction on the basis of the unlawful executive orders that set this whole series of activities in motion. And the appellate level affirmed the lower court's ruling. That's what we kind of have a little extra suspense. I really like, you know, watch this space, because the Supreme Court will take it up, as Chris had said. But in the meantime, if we are able to get a reduction of a tariff, if the tariffs are found not to be enforceable because they're unconstitutional, then the agency and the lawyers arguing for this have already represented to the court that not to worry, the judges are not to worry, because there is an ability to reimburse the tariffs. Now, you can only imagine letting go of cash and documenting your entitlement to the reimbursement, and then waiting for the federal government to actually pay the reimbursement. So the most that the owner can do is get the documents, make sure that you know, the paper chase is all tied up, and there's real clear authority for the owner having been the ultimate payor, and therefore the injured party, so that they're entitled to reimbursement. Those are all follow-on issues for an owner to take care of and keep an eye on, just like, you know, the warranty for the building after occupancy. And so there's one other thing. I think we got a question from our audience regarding, you know, what's the more advantageous project delivery system. We talked a little bit about like construction manager at risk, the pricing strategy of a GMP. In Florida, in the public bidding arena, design build has become a very preferred project delivery method. And because it's not going to be high design, where an owner wants to be close to that architect for the design of the project, although there are some that are like that. Most of them are design build with a desirable one-stop shop, you know, where you can go to just the contractor, design builder, and have accountability. And the other part about that is the owner with a design builder has a chance to get up close to the architect and negotiate and look at the specification of certain materials and equipment to see if there's any possibility that they can be procured from a lower tariff risk country, or if there is a better product, an equal product, say, in the United States, which when we have Buy America contract requirements because of FAA money or FDOT, Federal Department of Transportation money in the project, at least we've got, you know, a broader sourcing for procurement in an effort to keep the costs down. And so, you know, those are kind of my summary comments on what the owner is really worried about.
Thanks, Claire. Thanks for adding that. So I'm going to move us on to our next topic because I know it's a topic that our audience is really interested in hearing about, and it's focused on what are the contract clauses that you all have used or have found success in trying to equitably share and manage the risk of tariffs. And so I'm going to turn that over to Joe to start that discussion off.
Sure. So before we start digging into some of the specific examples we have of some contract language, including this one on the screen right now, you know, generally, I think that it's interesting to think about who can best manage this risk, because I'm sure, as many of us on this call have heard before, you know, the risk under a contract should fall on the party who can best manage and bear that risk. So, you know, between or among an owner, a general contractor, and their trade partners, which of those three can best control and manage this risk? And, you know, if I'm being objective about it, it's tough to say. This one is to some degree uncontrollable, right? And maybe this is my contractor side coming through, but ultimately, I think the owner is probably the one who can best bear this risk, in the sense that if tariffs got to a point where the job was no longer economically feasible, many times, more times than not, the owner will have the ability to either suspend the job or terminate for convenience. Whereas that's not really much of an option for the general contractor. And until our owner client has told us, hey, we're done, this is getting ridiculous, the tariffs have gotten out of hand, this job's no longer economically feasible, we're going to terminate for convenience, the contractor's got to keep on going, trying to meet its project deadline and build the project. So, you know, with that said, as Claire mentioned earlier as well, there are middle grounds or sort of compromises you can reach between owners and general contractors to reach sort of a point where everyone's sharing the risk a little bit. With that said, I would say there are generally two themes you'll see in a lot of the tariff contract provisions that we're going to show you all right now. One that I often see when I see tariff provisions from our owners is that they are going to include a duty to mitigate any of the tariff increases. And common examples of that, the number one that I've seen at least, is going to be that you're going to have a buyout deadline. So the owner doesn't want to enter into an agreement with you, and then the contractor takes 6 months, let's say, or more to buy out all of its subcontractors, and then find out 5.5 months later that additional tariffs have been implemented since you got a GMP amendment or some sort of agreed a price for the project. And now the contractor comes back and says, well, we've got these new tariffs. Well, the owner would probably say, you should have bought out your trade subcontracts much faster than you did. We wouldn't have this problem. So often, as part of the duty to mitigate, you're going to see a buyout deadline, you know, usually in the 90 to, 120 day range, something like that. As a part of that duty to mitigate, you also might find some requirements to, and this is particularly true for CM at risk contracts where the contractor is involved early on before the design's 100% complete, but to come up with some value engineering options to reduce costs, to plan out early procurement of some of the more sensitive materials that are needed for the job, like switchgear or elevators, that sort of thing. And also to potentially come out with warehousing strategies and I think Chris talked about this earlier too, potentially warehousing any of the things that you might need for a specific job very early. Let's buy them now. We know we need them. Throw them in a warehouse, and hopefully we can lock in our price earlier and avoid any sort of subsequent tariff changes or increases. So that duty to mitigate is probably the most common thing I see. The second thing I see occasionally theme-wise in these contract provisions from a contractor's perspective is sort of a proposal from some owners to, share the risk. Hey, Mr. Contractor, we're not going to shove this risk entirely down your throat and have your price increase accordingly. Let's work together and let's be partners. And why don't we share some of the risk involved with the potential for tariff increases? Oftentimes, and you can see that here in this AIA A133 language that's pretty vanilla, but could be used in an A133 contract to address tariffs. In 6.4.3 there, it's talking about that the contractor will basically bear the risk of the first 10% of an increase in the cost of the work due to tariffs. And then after that, that's when the owner will come in and start reimbursing the contractor for increases that increase the cost by more than 10%. So that value could be anywhere from 0 to 10%, maybe in that range. And the next slide, you can see another contract provision where it's a 5% at the bottom there. It's talking about the contractor will basically take on the first 5% of the risk of a price increase due to tariff-related causes. So that's one way that I have seen owners ask contractors to share the risk. Another, which is a little less common in my opinion, is a cap on the overall dollars or increases that might be associated with the tariff impact. The owner might say, okay, well, I get it. We don't know what's going to happen with new tariffs in the future. So we'll pay for them, but we've got to cap it. Tell me what you think the max possible increase might be for my project. And let's put that in the agreement. And anything above that's your risk, Mr. Contractor. Anything below that, I'm going to compensate you fully for 100%. I think that one's a little more difficult because, as we've all seen, the tariffs change so much that it's tough to say and predict what really will happen in the future. With that said, oftentimes you can come up with a dollar figure to cap it at. It's just probably going to be one that the owner's not thrilled with, but you can give it to them. So those are the common themes I've seen from the contractor's perspective for a lot of these provisions that we're going to go through. And Claire, I don't know if you had anything you wanted to add from the owner's perspective on some of these contract provisions.
Yeah, I actually do, because it gives new meaning and anxiety to the whole idea that used to be fairly benign, your termination for convenience provision. And while I'm not a big fan of termination fees and wouldn't advocate any of them to be invited in our agreements, I think it's really incumbent upon owners today really to pay attention to the downstream cancellation costs. I mean, it used to be, restocking costs, et cetera. It was sort of, could be just like peanuts. Okay, fine. This is the choice the owner makes. But when we terminate for convenience now, we really do need to think about what those downstream costs are before the owner pulls the plug. Not to mention, in particular, while we have that provision in all public owner contracts, the whole idea is, okay, what is this really going to cost us in the end? And also, what is the time to get to the board, to get the board to understand the degree of detail that we're facing, and also make a decision about a termination for convenience. Even where the executives can exercise that, but the board approval is still required, and the complexities. And so, tariffs have really increased the level of difficulty in terms of enforcing so many other provisions in the agreement, and made it that much more difficult to do business. The other thing is, when an owner clearly wants a good, solid contractor that can stand up under some risk, but we don't want idle time, have to pay for idle time, because that is the worst abomination when we're not spending our money for actual scope. And so, even though we've got the ability, can we, should we? And fortunately, I don't have to make that business decision. But in any case, this kind of information is very helpful for our owners to understand really and truly the true cost of a decision like a termination for convenience.
And Erin, I think you may have actually even skipped a couple of our example contract clauses, but for the benefit of the audience, obviously this will be made available after today's presentation. But there's a lot of hopefully some good standard form language and also a couple of custom provisions here that you might find applicable or helpful to your particular situation. So we could do this for 3 hours.
Yeah, exactly.
Yeah.
So Chris, there's a couple provisions you provided with regard to supplier quotations. Do you want to address those quickly?
Yeah, this is our my friends in Division 9 of the forum will love this. So look, from a supplier perspective, it is quite different than the GC owner perspective, right? You guys, we hire fancy lawyers, forum lawyers, American college lawyers. We hire fancy lawyers to negotiate contracts, think about all these risks and all that for a very large project. When it comes to the suppliers, as Claire said, and Claire is correct, oftentimes these multi-million-dollar transactions are done with 2 pieces of paper. There are no lawyers involved. So it is, it may be a surprise for a lot of you, but for suppliers and the council to represent our suppliers, it is incumbent upon us to make sure that they are doing their risk management appropriately. As we'll talk about with disputes that are on our desk right now, a lot of the disputes come from just not putting in the effort or the legal review of some of these clauses. So just these are a couple of examples, right, of where a supplier can insert a couple of sentences which either preserves its right after the quotation date. If tariffs change and they're assessed, we pass that on. And hey, if there's a refund or a credit, if we get that credit because the broker or the importer of record does it correctly, then we'll pass it along, right? There's a couple of provisions here, but no doubt it's really incumbent upon our guys to look at the purchase orders by the contractors that they receive and make sure we are inserting a tariff provision if one's not already there. I think that's appropriate in this day and age, or at least adjust your cost escalation provision, your force majeure provision, or some sort of specific limitation and ability to recover tariffs in your purchase and sale documents, which again can simply be 2 pieces of paper. That's going to be important to dictate our rights, duties, and responsibilities at the bottom of the chain.
So Chris, how often or how frequently do you see that there's upstream contract language incorporated by reference into your POs and supplier agreements? Is that common practice? Are they, and I'm assuming they don't really have some suppliers don't have aren't getting the access to those documents up front.
You would be correct. I mean, it's like our specialty trade contractors, right? A lot of them are the ones that just don't have the resources to do what you guys are doing and what we're doing today, to have these sort of webinars and share this information. So they get caught because they aren't looking at the documents that are incorporated by reference. So for sure, my sophisticated publicly traded clients have a better eye on seeing when documents are incorporated, and they'll either ask for them or they'll strike it and say, hey, I don't know what's going on upstream. I don't want to see your contract and your plans and specs. I'm just fulfilling this purchase order, and that's it. And this is my world. That's obviously best case scenario for the supplier folks, is not to deal with all the upstream stuff. But it's a little bit of everything, Erin.
Okay. And then we had a question come in from the audience. How do subcontractors handle tariff-related price increases when faced with no damage delay clauses? Like knowing that, tariff increases are more cost-based, but they could have a schedule impact in some way. I don't know, Chris or Joe, if you want to take that one.
Well, I mean, I think that would, by and large, depend on what your no damage for delay clause says. But assuming that you have an express no damages for delay clause that applies to you, then that could be a real issue if you're struggling to get the components you need to complete your work on time. And if that's something that's impacted your, I mean, it is possible. I could see, given some of the procurement delays you have with the tariffs that are being assessed, that could trickle both up and down, I would think, the chain of building the project. And, you know, if you want to have an exception for some sort of delays that are caused by procurement issues related to tariffs, that ought to be addressed in your contract. And you should try to get that in there.
Okay, and I have one more question that just came in. The supplier quotation clauses do not really help subcontractors. Their contracts include an incorporation by reference clause, which incorporates the general contractor's contract with the owner into the subcontract. So how do the subs protect themselves? So it's interesting. So we have owner, contractor, supplier, but what's the subs perspective there?
I mean, you know, I'll chime in to say that they obviously have to be cognizant of passing through, you know, what they can get for the pricing they can get. I mean, for sure, subs are often left holding the bag. They are the ones that aren't perhaps as sophisticated as the rest of the chain. So they're the ones that have to think through this at time of contracting and bidding. They've got to think through this stuff because, and most of the sophisticated ones know what they're going to see from the big distributors, right? They know when they're going to be able to you know, deal with the tariff issue when they're not. So I think it really forces them to be as proactive as possible, to be as proactive as the rest of the chain.
Okay, so that's going to lead us to our next topic. Considering that the tariffs or the current tariff situation is relatively new, I'm sure there's not really an opportunity to view case law that discuss disputes, and you can see what the outcome is, you know, related to these disputes and how they played out. So my question is, do any of you currently have any disputes that you're currently dealing with regards to tariffs? And do you have any predictions of how they might be resolved or how they might play out?
Are my clients on this call? Let's see. I've got several. So I've got everything from, you know, a project that's been canceled, and now I'm sitting on $10 million plus of goods. And what do we do? Who's responsible for that? I've got the project where my sub has not made the prepayments they were supposed to make, and we are worried about their solvency because they are left holding the bag, and we don't want to release those goods. And yet I'm getting the demand letter from Joe or from Claire saying, hey, you know, I know we're not in privity with you, but if you don't release these products, we're coming after you for all the delays. And this is a stadium, you know, a $10,000 a day delay damages, LDs, and you're going to be paying for it. So I've got that on my desk. And what do I do? Well, I've got some commercial code relief, perhaps, right? There's commercial code sections that give me the ability to suspend delivery if I have a reasonable insecurity that I'm going to get paid. If it's commercially practicable. What does that mean? That's why we get paid the big bucks, right? Lawyers get paid to argue both sides of that argument. And I to be honest, I've got the trickiest ones, the ones that I actually like, are sort of the battle of the forms issues, because we're trying to figure out what terms apply, because we have a one-page purchase order and, you know, terms and conditions of sale that appeared in a quotation or in an invoice, and you know, who is responsible? Does force majeure kick in? Does commercial impracticability kick in? I'll be honest, I think those are tough. Those tough equitable arguments. Obviously, it's contract driven. The more clear, you know, tariffs are specified in your force majeure provision, perhaps it can save the day. But otherwise, it's a tough one. And I don't think most triers of fact and your arbitrators are really you know, looking at those provisions to give relief to the supplier. So again, is incumbent upon our supplier folks to make sure that they hopefully have been as clear as possible up front in their quotation and the purchase and sale documents that start this process.
Yeah, I would just say in the public sector, we've been fairly fortunate so far that the amount of the tariffs imposed at the dock have been financially manageable. In other words, you know, not crushing to the owner. We're in the front end documents, trying to contract around this risk, and that goes for private and public. So that's where we are.
I don't know,
Yeah.
Joe, if you have anything to add. Oh, I'm sorry.
Yeah, real quick, I was going to say that, you know, I think that Chris's clients, you know, suppliers and subs as well they've become real focused on this issue. I mean, I'm seeing it raised more and more now. It is something that's on everyone's radar, which, you know, don't hold me to it. I haven't really read a lot about force majeure case law as of late, but now that it's on everyone's radar, it doesn't really see too force majeure-ish, if you will, at this point. It's not unforeseen. A lot of us are talking about, we got a whole webinar for an hour about it right now, right? So I can't stress enough the importance of everyone at every level included in your contract and expressly addressing it and allocating the risk however you guys see fit.
Yeah. One other thing I want to focus us on very specifically is, you know, typically the market has tolerated a 10% tariff on goods from almost everywhere. Now we've got stacking and all sorts of other kind of draconian measures that end up imposing additional costs on the project. And there are 3 executive orders that are the subject of the case that's going to the Supreme Court, at least out of the Court of International Trade. And it's those 3 executive orders that are the offenders that I know of right now. The AGC, ABC, and others have website information that's very, very helpful and interesting if you're interested in this area of, you know, cost on a project. And, you know, we're just going to have to see, I guess, you know, how it's all going to play out.
Yeah, you just round the corner, took us home, Claire. So that the last topic was, understanding that the Supreme Court is scheduled to hear the challenges to the tariff policies on November 5th. What may happen if the tariffs are found to be unconstitutional?
Yeah, I think the reimbursement aspect comes in, and the lawyers that represented to the judges that there was a reimbursement process are going to have to put their money where their mouth is. And, but I don't, with the way Washington is sort of in a log jam, we can argue the 3 branches of government, separation of powers, but it's anybody's guess where this will go.
Yeah, and you know, it opens up a tremendous can of worms. I mean, hundreds of billions of dollars of tariffs. Are we really going to make that, make any sort of order deeming the administration super or exceeding its powers retroactive? I can't imagine. And I guess it's possible, but then I could just see the flood of litigation, even involving the importers or the brokers who didn't properly, protest. And there's so much that could happen. I just don't think the courts or Congress would let that happen.
Erin, can I make one other point about, I think, Chris, you raised it about what we just saw on the news regarding China's additional costs, the additional charges. I understood that in addition to the tariff aspect of it, there are several other charges that China is adding on to things that are outside the tariffs. So, you know, everybody's kind of piling on, and you also have to be very careful about those costs as an owner, like what's getting loaded onto your products. So
Excellent point, Claire. That was in today's articles on Reuters. I saw that, like different kinds of fees, but they kind of fit in the same bucket,
Yeah, at the dock, those costs at the dock.
Erin, if I saw the last question come in from
Yeah.
Miss Bundy, so if I'll address that really quick, if that's okay, just so because I think it is important. Trade credit insurance generally excludes tariffs specifically. It's a business cost, not a credit risk. So that's usually not the product, but there is like some, there are some specialty products, political risk insurance or trade disruption or supply chain business interruption insurance that exist that are out there. I think there's some specialty carriers that do that. So there are products. You gotta research them a little bit, and hopefully you got a good broker that can do that.
Okay, so that pretty much sums up. Maybe I have another one coming in. I'm just going to ask if there's any more questions. where can the rules for stacking of tariffs be found to understand whether it's being improperly assessed?
Yeah, I would take a look at the AGC, ABC type sites because those guys, those guys are used to dealing with that level of detail and care about it greatly, and will show you how the formulation is to, you know, get you to an actual cost bottom line.
And I just want
Yeah, I
to,
think-
I just want to mention at the end of this presentation, we do have a slide of resources, and there is a AGC tariff center like website, and we have a link that we'll be distributing the slides after the
Yes, and
the
it's a very
presentation, so-
lively
yeah.
link because they update it, you know, like I think every day. It's a real time update almost.
And then there was a follow-up question. Where can one find the best outline for protest rules and basis for protest of tariff assessment? I'm not sure if your answer is the same, Claire, or if there's another resource.
That's an interesting one for me. I don't know the answer to it.
You might find that in some of the resources at the end of the presentation. There was a bunch of links that we put out there. You know, there is so I think I mentioned this earlier, but there's a 180-day deadline that's pretty strict to protest. So time is of the essence for these sorts of things. But no doubt there's a bunch of different, you know, guides, references with the harmonized tariff schedule that kind of come together, and that's what some of these brokers get paid the big bucks for, is to make sure they do it right. But hopefully some of the resources that we provided for you get you to the answer to your question. If not, you can always send me an email after, and I'm happy to get you specific links.
There was a lot of information to cover. I'm impressed we got through it in 58 minutes. So good job, panelists.
I just want to say I am proud to be part of a panel for a construction law panel that did not mention artificial intelligence once for a whole hour. That's got to be worth something, people. Come on.
Yeah, definitely to me.
We have a couple more minutes if there's any other questions to come to the chat. I mean, I know there were just some general administrative questions. As I mentioned, we'll be providing the slides after the presentation, and I do believe that the recording will be available on the forum's YouTube channel. So if you're interested in the recording or want to share that afterwards, it will be available.
Oh, we're movie stars. Hopefully you got an agent, Joe, that can, you know, make sure we collect on your on your royalties.
There we go. I love it. I love it. Well, thanks for your time, everyone.
Yes, thanks so much. And I just wanted to mention that we have 2 more webinars scheduled for this series. Let me just jump to the slide real quick. Oh, I went too far. There's one coming up on November 19th that's focused on labor related issues. So registration is now open for that. So be sure to register for that one. And then there's the last webinar in the series on executive orders and policy and regulatory changes is coming up on December 17th. So thanks everyone for attending, and we look forward to you attending the future webinars. And thank you very much to all the panelists. I really appreciate all your contributions.
And to you, Erin, you're
Yeah.
a star.
Thanks, Erin.
All right.
was fun.
Thanks everyone.
Bye, guys.